argued is Curtis versus Phillips. Ms. Phillips, you are the appellant and you will have 15 minutes to argue your case. You can also save some of that 15 minutes to respond to what Mr. Wiest argues. So before you begin, would you like to save any of your 15 minutes for rebuttal time?
Yes.
How much of that 15 minutes would you like to save?
4 minutes.
All right, I will keep track of your time, and whenever you're ready, you may begin.
Good morning. I would like to thank the court for the opportunity to share and allowing me to share this dispute with you all this morning. I am Deborah Phillips, and I am going per se. This appeal is involving the alleged board, Edith Thrower and Donnie Rutherford and Curtis, Milan Curtis. And I am here to discuss the wrongdoings that was done by that alleged board, and ultimately they received the final decision. Here we have documentation of Lyra Curtis and Edith Thrower and Donnie Rutherford submitting documents 3 times of the same document. And the document was Defendant Exhibit 7. And that same document was first given on October the 19th, 2015, but the Donnie Rutherford and Edith Thrower signed it in 2016. And then they did the document again in the body. It has 2015. And then they revised the document down at the bottom, stating that it was all in 2015. Then they had the same exact document that is dated on November the 8th, 2016, signed again by Edith Thrower and Donnie Rutherford, dated November the 8th, 2016, where they had replaced the document, replaced the signature and the date on it as well.
And in the body.
And so they corrected the body of the document as well as the date on the document. That's one of the things I would like to bring up that I'm bringing to the court. I also want to talk about how Edith Thrower prepared the documentation for Lyra Curtis to transfer the deed into his name, charged him $10, and then gave him the corporation to handle it personally. Lyra Curtis, he said that he had done it, and the judge did make him turn the deed back into his name, but he continued into the property's name because the church is deeded to itself. He continued to, when he changed the deed, he added his deceased mother and stepfather onto the deed, and they continue on the deed even as of today. And so it made it look like it was an inheritance for him, or a part of her estate, that he would inherit the property of the church. And the other thing was that Lyra Curtis, Edith Thrower, and Donnie Rutherford went into a purchase agreement with Pauline Vanderhauer. And in this purchase agreement, he received $500 that solidified the purchase agreement. We wasn't notified about the purchase agreement until 2018. So when we seen the Honorable Melba Marsh in her office, in her chambers, not in her chambers, but in the courtroom, when we seen Dr. Melba Marsh, she said that the place was not supposed to be encumbered, that nobody is to sell, nobody is to do anything to the property, but she named Lyra Curtis as the caretaker of the property. But he had already went into a purchase agreement in regards to the property. Also, Curtis and Rutherford, the trial court went passed our bylaws for our church. Our church was operated and incorporated by the previous pastor, Pastor Mary Pearl Roundtree, and it was incorporated in the with the state of Ohio. With that said, the trial court had
Ignore the structure.
the trial court ignored the structure of.
Ms. Phillips, I can't help notice that there is somebody with you. And we certainly don't object having you have somebody there with you. But it is distracting to have that person telling you what to say. This is your chance to argue, and take a deep breath. I know you're representing yourself, and that's not an easy thing to do. But if you could just continue without the maybe the whisperings of who's ever with you. And again, there's no need for that person to leave. And if you need some assistance, take a deep breath and maybe could have a conversation. I'm not counting this time against you. I'll add a little bit of time to your argument.
Thank you. Okay. Thank you. And I value your time, and I appreciate it. As I was stating, that the trial court had dismissed our bylaws and went with the state of Ohio bylaws. And as a result, was saying that I was dismissed, or the church bylaws was dismissed because there was not ample time. People did not receive their notices in time in order to come to the meeting, the business meeting for the church. And this was the way that the church did things was through the bylaws. They announced it over the pulpit, and then they had the meeting that following week. Everyone knew about it. It was by Donnie Rutherford. He had heard about a meeting on hearsay, that he had never received any notices. And that is in Rutherford had said, I'm sorry, that he had never received any notices as a result of the meetings on October 2015, but that was of hearsay. And that is found in the volume book 2 of 2, page 107. I'm sorry, page 101, line 13 through 17. And then the Sisters of Geraldine White, who were members of the church while she was alive, while Elder White was alive, and they say that they were members of the church then. They also said that they did not receive any notices or of a new board being formed in October of 2015. And that's on page 107, 12 through 16, in the volume 2 of 2 of the transcript. That was Helen Burgess and Marilyn Washington. Marilyn Washington's statement was volume 2 of 2, page 263, 19 through 25, and page 264, 1 through 4. Now, it's alleged that I have not been, I was a stranger, that I have not been a part of the church. And I have been a part of the church from my youth, from the age of 9 years old. Edith Rohr states in her testimony, in her transcript, that Geraldine White and Deborah Phillips had a positive relationship, not only with church, but personally as well. And Marilyn Washington states that their family had known me for over 20 years. So I was not a stranger of the True Holiness Church of God. Donnie Rutherford said, oh, I'm sorry, I didn't give you the page number for Marilyn Washington. That's page 257, 15 through 18, lines 15 through 18. And Rutherford also said that he seen Deborah Phillips running the service and that I was in the pulpit. And that was in the transcript on page 99, 17 through 23, and volumes 1 of 3, page 182 through 6. it was also stated about Ford, Robin Ford. And he testified that he had seen me in the church operating the services as well. As a result of the True Holiness, my board, the True Holiness Church of God of Mount Auburn, have had a lawyer since December the 8th of 2016, all the way up until September 6th of 2019. So we have never been without counsel. This is the first time that we have been without counsel. And the only reason why we're here today is because we found so many discrepancies with their testimonies of the depositions, as well as the transcripts. And a couple of the depositions, Deborah Greer had testified against me for the other party, saying that she knew the family well since the 70s, but she didn't know who Pastor Roundtree was. And if you knew the family, you had to know the matriarch of the family, which was Pastor Mary Pearl Roundtree. And she also said that Geraldine White wanted the doors of the church to stay open, and she would never want to sell the doors of the church. And so because of that statement, Deborah Greer, she said this in her testimony on page 363, lines 1 through 7, and on page 357, volume 2 of 3, 362, 21 through 25, 363, 1 through 7, and page 357, 6 through 8.
Ms. Phillips, you have about 1 minute left if you want to reserve your 4 minutes.
Okay. All right.
If you'd like to save your time to respond to Mr. Wiest, I will add a minute onto it and let you reserve 5 minutes if you prefer to do that.
Thank you. Thank you. I'm sorry. I appreciate your time.
Nothing to be sorry about. I know it's difficult to be a pro se person arguing. So thank you. I will add that extra minute to your rebuttal time. Mr. Wiest, you have 15 minutes.
Your Honors, we submitted a brief in this matter that I think addressed the assignments of error of the appellant. And I think to be respectful of the court's time, I would just say this. The trial court had a 3-day bench trial. The trial court saw a great number of witnesses. The trial court decided which witnesses it believed and which witnesses it did not, and entered findings of fact, all of which were supported by record testimony in this case. You know, were there two competing stories about what happened? Absolutely. And the trial court was in the best position, as this court's aware, under the general decision to decide who it believed and why it believed it. Now, I understand Ms. Phillips disagrees with those factual findings, but those factual findings have support in the record. Judge Allen saw and heard the witnesses live, and she was entitled to make the findings that she did. I've looked at the conclusions of law of the trial court. I think that those are also supported. I don't think there's any basis to challenge those either. And for all of those reasons, Your Honors, I think this is a straightforward appeal. While Ms. Phillips certainly disagrees with the factual findings, there was a basis for Judge Allen to enter them, and there was testimony that she was entitled to rely on to do so. So, we would ask that the decision be affirmed, and I am happy to take any questions that any member of the panel has regarding any of the issues in this case.
Any questions from the panel?
Thank you, Your Honors.
Ms. Phillips, you have 5 minutes if you'd like to use them to respond.
And before you begin, Ms. Phillips, could I ask you just a kind of a nuts and bolts type of question? Before this controversy arose, how was the day-to-day, business of the church conducted?
And you're on mute. You need to unmute yourself.
Thank you.
Yeah.
Now, can you hear me?
Yes.
Okay. The day-to-day business of the church was we opened the church doors, usually during peak hours. We offered prayer. We offered,
I don't mean the chronology. I mean,
I'm sorry.
who would make the decisions for the church body?
I made Pastor Jardine White instructed me to go out and make the decisions. I submitted many documentations from the city that I operated in because the church was hit by a car. Went to court. I operated in the litter control. I did all of those things. Talked to Aaron Ice on behalf of True Holiness Church of God, and my name is addressed to many of the documentations that was submitted in evidence in regards to that. So I was, Pastor Jardine White had given me permission to go and pursue all of the things that needed to, the day-to-day basis that had needed to happen for the church.
Thank you.
Yes. Okay, so in my closing, I thank you again for allowing me to do this, but I just want to say that, yes, that there has been, the court did have their findings. We see when we look into the injunction that Lear Curtis was given the injunction, and then there came a modified document. We had no knowledge of the modified document that was submitted on behalf of Curtis and et al. And so we didn't have a chance to rebut that. Also, we tried our best to work it out and make sure that everything was done like it was supposed to be. But when Curtis was legally voided, we thought that Rutherford and Donnie and Thrower would have been legally voided as well, because their documents are the documents that put him into play, that allowed him all of these fraudulent acts to happen. And these fraudulent acts happen against the city, the state, and the clerk of courts. These are all documents that were submitted, false documentation. And everything that I submitted was in the year of 2016. Everything they submitted was back in 2011, 2009, 2012. And so I'm saying, if all of their documentation was true, if they were the true finders, and if Edith Thrower and Donnie Rutherford were the true alleged board of trustees, why did they have so many discrepancies? They had discrepancies, and when they were appointed, Rutherford said he was appointed by Edward White. Then he turned around and said he was appointed by Jardine White. They both said that they were only put as representatives for the statutory agent, that they never was trustees. These were things that came out of their mouth. And the judge just looked over it. They were appointed caretakers of the church, and they did not care for the church. They have a lot of violations. They have a lot of laws that they had broken. And so therefore, we have tried ourselves to go through all of the documents, and these are the things that we found. We feel that it's unfair that the church has been taken away from the true pastor of the True Holiness Church of God. She appointed me with an appointment letter. Neither of them have any appointment letter appointing them as the True Holiness Board of Trustees. Only thing they signed as representatives as the statutory agent. And so I'm asking the court to look upon these findings, to see everything that has happened with the discrepancies. I understand that the judge was there, but everything was not documented in the, it was documented wrong in the injunction. And so therefore, when she made the decision, she had to go back and legally, even though she gave it because of Lear Curtis' problem, because of him, his merits, family ties to the church, then she came back and legally voided him. So all of the ones that was in cahoots with him should have been legally voided. I just want to present this case. Hopefully I made a little sense in regards to it. Any documentations, all is on file, and I submit myself to the court.
Ms. Phillips, thank you very much for your argument today. Mr. Weiss, Ms. Phillips, we will take this case under submission. We will give you a timely written opinion. Again, thank you both for your arguments this morning.
Thank you.
Ms. Hayden, if you will allow the next parties into the courtroom. Good morning. I want to make sure we have everybody here for our next case. Our next case this morning is State versus Paget. And I see somebody is participating by telephone. I assume perhaps that's Mr. Kilborn on behalf of Mr. Paget.
Yes, Your Honor, and I apologize. I've had some technical difficulties this morning. I've been trying to log on via Zoom since about 8:30, and it had worked in the private meeting, so it looked like it was about to work just now when I tried to join.
Well, we can hear you fine, so no worries. We're certainly able to hear you, and if we have any problem with that, we'll stop you and let you know. Ms. Adams, I see that you are here on behalf of the state of Ohio. Mr. Kilburn,
Yes, Your Honor.
Mr. Kilburn, you will have 15 minutes to argue this morning. Would you like to reserve any of that time for rebuttal?
Yes, Your Honor.
How much would you like to reserve?
Your Honor, if what is my maximum limit?
I suppose you could reserve 14 minutes if you chose.
I'll do for the rebuttal. Let's do 3 minutes, Your Honor, please.
All right. And I see that you are trying to connect again. I will give you just a moment to see if it works.
Can you all hear me?
Yes, but with quite an echo because you've got two devices going.
Sorry, I thought it was muted. Is that better?
Yes, for now. Will you speak for a moment so we can hear if there's an ongoing echo?
Good morning, Your Honor. Steve Kilburn on behalf of appellant Brandon Paget this morning.
That's okay, but I will say that we cannot see you. We can only see your name. So I think you need to turn your camera on. There you are.
There he is.
All right, looks like it's working. You'll be able to hear if there's an echo because you'll hear it as well. But I will note that you're reserving 3 minutes, and whenever you're ready, you may begin your argument, and I'll let you know when you're out of time.
Thank you, Your Honor. On December 28th of 2019, Mr. Paget was cited with failure to maintain reasonable control and operating his vehicle while impaired in Sims Township, Hamilton County, of course. Officer Nick Price responded to the scene and observed an overturned vehicle, which he described at the trial as a Navy Dodge Challenger, Dodge Charger, that had struck a tree and was overturned in a wooded area. He testified as to what he immediately observed, not only the vehicle, but he did see Mr. Paget as well, standing freely by another police officer's cruiser. There had apparently been 2 other officers that arrived just prior to Officer Price. He testified Mr. Paget was not leaning against the vehicle. He was standing freely and no apparent issues, unsteadiness on his feet or anything like that. He took a closer look at the vehicle and sees a pool of blood, what he described as a pool of blood on the interior ceiling above the driver's seat. And he said he saw an imprint of blood on the airbag that was deployed. After this, he approaches Mr. Paget. He says he smells an odor of alcohol. And he concedes that, consistent with his training, NHTSA training, he's supposed to look for the intensity of the alcohol, but he doesn't remember how intense this odor was. He did not even note it in his ALS report. But he said that he noticed bloodshot and watery eyes and an odor of alcohol. So those two things. He said that Mr. Paget was cooperative, and he noticed very little blood on Mr. Paget's face. Very little is how he described it. So let's talk about what Officer Price did not see. He never sees anyone drive the vehicle. He never finds the keys or the ignition device to the vehicle that was crashed. He never hears any any admissions as to who was, or any information as to who was operating the vehicle at the time of the crash. It's undisputed, and Officer Price concedes this explicitly during the trial, that he does not know. He simply does not know who was operating the vehicle. He does not see any blood on Mr. Paget's hands or his wrists, anything like that. And in fact, he has good reason to doubt Mr. Paget was driving the vehicle because he learns during the course of his investigation that there were two other individuals who were occupants of the vehicle who had fled immediately after the crash and on foot. And he speaks to the officers who observe these individuals bleeding from their hands, so much so that blood is transferring from their hands onto the documents that they're filling out. The police have them written statements. And notably, the officer never observed these individuals' injuries, and so he never compared their injuries with that of Mr. Paget's small scratch on his face, and never compared their injuries with the imprints in the vehicle. Notably, the officer does not try to do a DNA test or match the blood on the ceiling of the vehicle or the airbag. So there's no kind of DNA match or anything like that. And importantly, these two individuals were intoxicated. So they're bleeding and they're intoxicated, and they're undisputedly a part of the situation. They were in the vehicle at the time of the crash. So regarding impairment, the officer, let me back up. So I think it's clear there is not sufficient evidence here to determine who was operating the vehicle at the time of the crash. Simple. I mean, I think that's undisputed. I mean, the officer concedes that on the witness stand. Regarding impairment, Officer Price says Mr. Paget was not slurring his speech. He was not unsteady on his feet. He says he does not find any alcohol in the car, no bottles, no cans, nothing like that. No admission to drinking, no field sobriety tests that were performed. Mr. Paget respectfully refuses. No breath, urine, or blood tests. And it's interesting because during the trial, the Officer Price never testified as to why that was the case. He never said that Mr. Paget refused. I think I don't know what happened there, but it wasn't clear to me why there was no test. But bottom line is there wasn't. When the officer was asked about lack of clues of impairment, the officer simply says, quote, based on the totality of the circumstances, I had enough that I would consider probable cause to arrest Mr. Paget for the arrest of, for driving his car. And so this case is just, I mean, there is absolutely no sufficient evidence to believe.
Mr. Kilburn, you are frozen. I want to make sure it's not me that's frozen. Judge Hendon, can you hear me?
I hear nothing.
You can't hear me either?
No, I can hear you.
Oh, okay.
He's just gone
Right.
completely silent.
Mr. Kilburn, we have lost you. You are frozen.
I'm on
Okay,
I'm on the phone. Can you hear me now?
yes.
Okay. I think we lost connection. So should I continue? Can you guys hear me?
Yes, you may continue. You've got about 5 minutes left of your original time.
Thank you, Your Honor. So when asked about the clues of impairment, or lack of clues of impairment, rather, the officer testifies. He says, based on the totality of the circumstances, I had enough that I would consider probable cause to arrest Mr. Paget for the arrest of, well, driving his car. And he's specifically asked about sufficient clues of impairment or lack thereof, and that's his response. So it is very clear with respect to impairment, there are two clues, and those two clues are bloodshot, watery eyes, and odor of alcohol of an unspecified intensity. That is absolutely it. And those two clues alone are just entirely insufficient. And I think that is the law in this district. I think that the trial court believed that those two clues, coupled with the fact that there was an accident, were sufficient. However, to consider the accident as a clue of impairment, one must assume that Mr. Paget was driving the vehicle. And, there is, in this case, assumption after assumption after assumption. Even the officer, with respect to operation, simply says, he simply assumes the blood in the car is Mr. Paget's, and therefore Mr. Paget was driving. It's circular reasoning because it assumes he was in the driver's seat to begin with. There is absolutely insufficient evidence in this case to come to the conclusion that he was operating his vehicle and that he was impaired. And I think more specifically with respect to, and I don't know if I mentioned this already, but the two other occupants in the vehicle, they were clearly impaired, number one, based on the observations of the officers. And second, they were clearly bleeding to a sufficient degree such that the blood from their hands was transferring onto this documentation. The officer never compared these individuals' injuries or their cuts with the imprints in the car or with Mr. Paget's injury. And the officer gives an explanation as to why he believed Mr. Paget was driving. And he says something to the effect of, well, these individuals didn't have a type of injury that I would consider sufficient. These individuals did not have some type of injury that would lead me to believe that one of them potentially caused the blood to imprint itself in the car. But I mean, clearly they're bleeding on this paper. So I think that this was a rush to judgment and just an assumption after an assumption that ultimately led the officer to believe Mr. Paget was operating his vehicle and that he was impaired, and same with the trial court.
Mr. Kilburn, was
Yes.
there evidence in the record of who owned this car?
I believe there was. It is Mr. Paget's vehicle, and I believe that the officer did testify to that. And
Can't that be considered as at least circumstantial evidence of who was driving the car?
I don't see how it could. I mean, it certainly could. The trial court even mentioned, well, somebody who owns the car would tend to stay, and therefore I believe and because Mr. Paget remained at the scene, the other two people fled. It seems to me he was driving. Well, I mean, what
about I wouldn't entrust my car to other people who are clearly impaired? Isn't that circumstantial evidence of who was driving?
Not necessarily. I mean, I don't believe so. I mean, the officer did not go into detail about, how impaired these individuals were, the level of impairment. I just think that it requires an assumption that was not testified to. I mean, it's just an assumption. I mean, I don't think it's
I'm sorry,
sufficiently strong circumstantial evidence.
I thought I just heard you say that the other two were clearly impaired. And that's why I asked that follow-up question. Is that not in our record?
I actually thought that was in the record.
Yeah, I think the officer testified that the other officers, Officer Price testified the other officers observed these individuals and that they were impaired. Okay. So, but it assumes that Mr. Paget, had knowledge of their impairment. I mean, if we're going along with the idea that this is circumstantial evidence, I mean, So I think that, I mean, I don't think that, we can say that, Mr. Paget would have been driving because he had knowledge that these people were impaired. I mean, did he put them through field sobriety tests? I mean, the officers would have a much better understanding as to this than Mr. Paget would.
All right, and you are at your time, Mr. Kilburn, if you'd like to reserve 3 minutes.
Thank you, Your Honor. I would like to do that.
All right, Ms. Adams, you have 15 minutes. You are muted, Ms. Adams.
Thank you. Sorry. Good morning, Your Honors. I think that what Mr. Kilburn characterizes as assumptions in this case are actually the circumstantial evidence. And fortunately, since this matter was tried before the bench, we have a very thorough analysis and explanation exactly. We don't have to guess what that evidence was that the trier of fact found to be pertinent and proof of the allegations here, because the trial court sets forth his analysis, and the state certainly thinks that the judge, and he starts with indicating that he's taking into consideration the 13 years of experience that this particular officer has, and all of the surrounding circumstances of the accident and the degree of it. So certainly all of that, Mr. Paget was the only one that was described to have a facial injury, and what I think Mr. Kilburn characterized as a scratch. I think the judge said it was actually a facial laceration. He indicated the blood that that dripped. There was also blood on the airbag, and also Mr. Paget sustained a broken wrist. So these were all factors that the trial court specifically noted with regard to the circumstantial evidence going to operation of the vehicle. And then certainly those physiological factors. I would maybe disagree with the characterization that we don't have a degree of or a level of the odor, because I believe that the officer went so far as to say it appeared to be emanating from his pores, which to me, I think that would be a strong odor of alcohol. So I certainly think that all of these explanations that were provided by the judge indicate that there was certainly sufficient evidence, and the weight of that evidence was in favor of finding Mr. Paget guilty of both of these offenses. Unless the court has any specific questions, I would submit the rest.
Ms. Adams, this coming through his pores comment that the officer made, was there anything in the record that would have indicated that there were open containers or something in the car that might have contributed to that odor coming through his pores type of thing?
Not that was in the record, Your Honor, no.
Any other questions for Ms. Adams? All right, Mr. Kilburn, you will have 3 minutes left.
Thank you. Well, first, the state mentioned earlier, the judge characterized this as a facial laceration. Well, I mean, maybe that's what the judge said, but it doesn't matter what the judge said. The judge wasn't there. It matters what the officer said. And the officer said, I don't know if he was specific about what kind of injury, but I think he mentioned a small cut on Mr. Padgett's face. But the point here is, regardless of the nature of the injury on his face, the officer was very clear. There was very little blood on Mr. Padgett's face. And so, you know, we can't have it both ways. We can't say, well, there's a lot of blood on these individuals' hands, but there's very little blood on Mr. Padgett's. But, you know, there's blood in the car, and yeah, it's consistent with Mr. Padgett's injury. I mean, but why think that? I mean, look at the level of blood. Look at the amount of the blood. Further, there was the state mentioned Mr. Padgett had a broken wrist. That was never introduced into the record. He complained of an injured wrist. But I mean, who wouldn't in a vehicle, regardless of where you're located in the vehicle, who would not sustain a type of injury like that? I mean, that should not be surprising to anybody here. And it certainly does not indicate he was in the driver's seat. So again, I think that the state is really, this is a desperate attempt to try to prove Mr. Padgett was driving, but it relies on circular reasoning. And again, with respect to impairment, I think that this district is very clear, even assuming the state had sufficient evidence to show he was driving. I mean, the case law is clear. Bloodshot eyes and an unspecified odor of alcohol are insufficient clues to establish proof beyond a reasonable doubt that a defendant is impaired. And, you know, it is abundantly clear from the record, there are only two clues of impairment in this case.
Mr. Kilburn.
Yes.
I'm sorry to interrupt you, but when you make an argument based on manifest weight, you've got a high hurdle here. You've got to show us that essentially the trial court lost its way, just made a huge, hideous mistake. Now, given the fact that we have evidence of ownership, we have the blood spatters that apparently correlated with the injury to the defendant, you have the odor of alcohol, you have the ownership of the vehicle. Where did the trial court lose its way? Can you point to something that the trial court completely ignored or
Yes. So when
help
you
me
just
out.
described that, you mentioned ownership twice. So I think that those factors, that was a redundant item on the list. And then secondly, you mentioned the trial court found that this blood matched or was more consistent with Mr. Padgett's injury. Well, why think that? I mean, he had a small cut on his face and he was barely bleeding. These other individuals had blood all over their hands. I mean, that is an assumption. So I think,
Well,
the trial court disregarded.
Except if you hit an airbag and you're the driver, you're going to hit with your face. So the blood would be from somebody's face, not their hand.
Well, sure. And these other individuals may have had blood on their face. I mean, the officer didn't see these individuals. He just knew that they had bloody hands and the documentation they were signing had blood on them. So, you know, I mean, I think that it's good. But I do think the trial court disregarded entirely the fact that there were two other individuals in that vehicle. I mean, that's rather significant. And they fled. I mean, why would they flee? I mean, to me, it seems like if you're guilty of something, you flee. And so my guess is that these are, you know, I mean, I think it's more consistent with somebody who was operating the vehicle to have fled.
And Mr. Kilburn, you are at your time unless the panel has any additional questions.
Thank you.
All right, hearing no additional questions. Counsel, thank you both very much for your arguments this morning. We will take this case under submission and give you a timely written opinion. And with that, I will ask Ms. Hayden to invite next case into the courtroom. We also will have another judge substituting in for Judge Winkler's place, a judge who's assigned to the other panel. panel.
Thank you.
Good morning, everybody. Our last case on the docket this morning is State versus Holden. I see that we have everybody in the courtroom this morning. Mr. Whitfield, you will have 15 minutes to argue. Would you like to reserve any time this morning? I'm sorry, I'm getting my next cases out here.
You're fine. Good morning, everyone. I would like to reserve about 5 minutes, Your Honor. 5 minutes.
All right. Whenever you are ready, you may begin.
Thank you. Again, good morning. May it please the court. My name is James Whitfield. I represent Bradley Holden in this matter. Mr. Holden filed his notice of appeal and his brief as a pro se litigant, and I've been fortunate enough to be asked to join the case today. And he presented 2 issues for argument in his brief, and I'll just address them in that order. His first issue was his denial of counsel, and I'm sure the court is fairly familiar with the case, but he filed a motion to withdraw a plea he entered. And once he filed that motion, it's important that the order, because he filed that motion as a pro se litigant, and then he went out and hired counsel. Counsel was supposed to be Mr. Bennett, referenced in the record.
Was there any indication that Mr. Bennett joined that motion or had appeared for purposes of arguing that motion?
I believe Mr. Bennett was aware of the motion. Mr. Bennett basically Mr. Holden stated that he hired Mr. Bennett for that purpose. So obviously I can't speak for Mr. Bennett, but I believe he knew that there was a motion to withdraw the plea. That was what was pending that day. Whatever his schedule was, it prevented him from appearing. But
Mr. Whitfield, it was my understanding that Mr. Bennett filed his designation in conjunction with the probation violation that was contemporaneous with all of this going on. Am I not correct about that?
I think he filed after the violation was filed against Mr. Holden. Mr. Bennett entered his appearance on November 13th of 2019.
Well, and the probation violation was apparently on November the 11th. So it must have all happened together, as best as I can tell.
And Mr. Holden had fired, and I'll agree with that somewhat. It's the same period of time, because Mr. Holden filed his motion maybe a week or about 2 weeks before. He filed before the probation violation came up.
Now, he was found guilty of violating the terms of his probation, was he not?
He was.
And did Mr. Bennett represent, I'm not sure this is part of our record, but did Mr. Bennett represent him at that probation violation hearing?
It is not part of the record, but I would assume that he did.
It's my understanding that he did, in some limited capacity at least. But the probation violation apparently had little or really no impact because Mr. Holden was returned to probation, correct?
Correct. Mr.
Okay, so
Holden's probation.
By that time, the motion to set aside the plea had already been filed. That's also correct.
Correct, Judge. That's correct.
How then, and this is where the whole case really hinges, how then is the court, now I'm talking about the trial court, how's the trial court supposed to know that counsel is attached now to the motion as opposed to having concluded the probation violation representation? Because when I look at Mr. Bennett's designation, he doesn't say for what purpose he simply files a standard designation.
That's correct. If you look at the record and the transcripts, Mr. Holden indicated to the court the day of the hearing that Mr. Bennett was hired for that purpose. And I can quote it, but he said he was hired for the specific purpose, which was to argue the motion.
Where does he say that?
That would be, I believe it's page 2 or page 4, Your Honor. I'm sorry, it's page 4. And Mr. Holden stated the reason was that I actually hired him for this, and he told me to ask for a continuance. And that's the top of page 4 in the transcripts. And I'm sorry, that's the volume 1 transcript from November 20th, 2019.
Mr. Whitfield, let me ask you a follow-up question. And I know, and I do appreciate that you were brought in after all the briefing was done, after the record was submitted to us. So I don't know that you'll really be able to answer this question. But at the probation violation hearing, which occurred after the denial of the motion to withdraw the plea, but at a time when Mr. Bennett was representing your client, we don't have this transcript, and because I guess it wasn't ordered. But wouldn't Mr. Bennett have said to the trial court, "Hey, you held this hearing on this motion without giving me a chance to argue it"? Wouldn't he have raised some objection before pleading his client out to a probation violation on the very charge that his client was arguing he should be able to withdraw his plea? And what are we to do with that, I guess, is, and maybe because it's not a part of the record, we can't even consider it. But that's been something on my mind, that if Mr. Bennett really was representing him for that motion to withdraw, wouldn't we have something in our record? Because so much happened after that, including pleading to a probation violation.
I would tend to agree, Judge. I would hope that Mr. Bennett would at least have mentioned that in that hearing and perhaps try to avoid the violation altogether based on that. But again, I wasn't present. Mr. Holden and I haven't discussed that. I don't think Mr. Jackson's co-counsel, we haven't discussed that either. So I can't tell you either way. I would hope that he would have raised that. I would hope that that would have been spoken and brought up. Unfortunately, it wasn't. But we do have, I don't want to say documentation, but it's pretty clear that Mr. Bennett knew that the motion to withdraw the plea was taking place, that he couldn't be there, that he advised his client, and that he was definitely attorney of record. So Mr. Holden had counsel. He advised his client to request a continuance.
Was the error the failure to grant the continuance?
It was, Your Honor. That was the big error here, because he clearly had counsel. And it wasn't a case, and I read the briefs that were submitted both by the state and by Mr. Holden, and I read some of the case law that's included in the state's brief. And this wasn't a case where an individual defendant had an attorney and then went out and filed a pro se motion. And the order makes a difference, because this is a case where, and the defendant had a right, Mr. Holden had the right to file a motion as a pro se litigant, but then he went out and hired an attorney for that specific purpose. So he had counsel.
So you're saying that the order makes a distinction in terms of if you have an attorney and you file pro se, that's the kind of hybrid representation that is not permitted. But if you don't have an attorney, you file pro se and then you get an attorney, the rule should be what? That then you have the attorney must be present for the hearing?
Correct. That's correct, Judge. That would be because he's hired that attorney, he still has a right to counsel. He's hired an attorney, the attorney's unavailable, it's akin to the attorney being sick. And in this particular case, Judge pretty much forced my client to go forward with the hearing. He didn't ask him, he didn't even ask him really, he didn't do an analysis if he was waiving counsel or not. He just told him, we're going forward today. And then he got into, I guess, the merits of that case, whether or not he was going to grant the motion. And so it's the second part of what Mr. Holden raised, and I worded a little differently. But that hearing, it was more of a knowing and voluntary plea discussion. The judge just simply asked him, Mr. Holden, you were here before me before. I asked you when you were entering your plea, did you understand the charges against you? Did you understand that you face these possible penalties, things of that nature? Mr. Holden indicated that he did understand that he did, that he was present and he entered the plea, but that wasn't the standard that we believe should have been used at that type of hearing. Had Mr. Bennett been there or had counsel been allowed to come, I think that we could have got to the main issue, and that's whether or not his prior counsel's performance was deficient, and if that deficiency hurt Mr. Holden's position. And
So are you asking us to remand it to the trial court for a hearing on the motion to withdraw where your client can be represented by counsel if he chooses to hire counsel again?
Yes, Your Honor, that's the main relief we want. I mean, Mr. Holden hopes, that this can be lifted from his record because this is a fairly serious charge. Is going to follow him for life. But at a very minimum, since he filed a motion to withdraw that plea, he should have had a hearing on that. And he had counsel, and his counsel should have been allowed to come in and present an argument and kind of make the argument that I'm making now. What standard needs to be used, what needs to be held, because it's clear that this is, post-sentence.
And you would say it's irrelevant to our decision, since it's not part of our record, what happened at any of those subsequent probation violation hearings. And I also assume if there was something in the record that would support the state's position that counsel didn't intend to argue or did actually argue it, that the state would have ordered that additional transcript for our consideration.
Well, I don't want to speak for Mr. Tucker either, just like I don't want to speak for Mr. Bennett. But like you said, I'm not privy to that information, so I don't know what happened. It could have tilted the scales in either direction. Like you said, Mr. Bennett may have said something, and Mr. Tucker may point out that Mr. Bennett did not say anything. But, based on what Mr. Holden filed and what I believe to be the law, because he had counsel present at that day, or not present, but he was retained by counsel on the day of his hearing, he could have probably requested a continuance, and that continuance should have been granted.
I just had a rather unsettling thought. If in fact the court were to grant the relief that you're seeking, which is to remand it back for a hearing to be represented by counsel, which at this point we're all saying is Mr. Bennett, and it goes back to the court and Mr. Holden appears pro se, then what?
I think Mr. Holden can appear pro se, but he has to be given the opportunity to waive counsel.
Well, does he?
Judge Hendon, I had a case like that when I was in practice. We won because the trial judge had not allowed the defendant to appear with a lawyer, and then it goes back and he decided to be pro se.
Mr. Whitfield, let me ask you a follow-up to that, however. It's a post-conviction motion. Is your client entitled to counsel? Certainly if he retains counsel, I think there's no question that counsel should be able to argue. But if he appears, as Judge Hendon suggests, pro se, either because he's chosen not to hire somebody or for whatever reason, the court doesn't have to appoint counsel to represent him, does it?
It does not at that point.
All right. So I guess that was a follow-up. You can tell we had a lot of questions for you today and probably disrupted your planned argument, but you are over your time if you want to reserve 5 minutes. And again, I recognize that's because of all our questions, and we may have some more for you on rebuttal.
Rebuttal's fine, and I like questions, so there's no issue at all, no problem.
All right, thank you. Ms. Tucker, you have 15 minutes. And you are muted.
That's not the first time that's happened.
And it
Good
probably
morning.
won't be the last.
It probably won't be the last. Good morning, Your Honors. My name is Ashton Tucker, and I am representing the city of Cincinnati in this matter. I want to first touch on the first assignment of error, which my reading of Mr. Holden's brief is that the first assignment of error is that the trial court erred in denying the defendant's pro se motion because he was represented, or excuse me, motion to withdraw his plea because he was represented by counsel. And I guess
reading. what's wrong with Mr. Whitfield's point that it's a distinction between a case where he had counsel and now is filing something pro se versus he was pro se, subsequently retains counsel, and all he says to the judge is, "I'd like my lawyer here." I mean, what's wrong with that?
Well, I don't think that that's necessarily, that part is necessarily a problem. What I think the issue here is that the court could not have properly heard the motion to begin with. Because the motion was filed pro se and he was represented by counsel, and we have no indication that counsel has joined the motion in any way or has indicated the need for relief as the pro se defendant has asked for. The trial court can't properly consider that motion to begin with. And that's sort of where I think this hinges. That's State v. Smith, 2017, Ohio 8558. So in the case before this court, it's my understanding that the defendant, or Mr. Holden, filed the motion to withdraw his plea pro se and then was represented by Mr. Bennett on the probation violation. But Mr. Bennett, there's no indication anywhere in the record that Mr. Bennett had signed on to the motion or indicated
when
any need.
you said he was represented by counsel when he filed the motion. Who was his lawyer?
I may have misspoken. I don't think he was represented by counsel when he filed the motion. I think he was represented by counsel for the probation violation specifically. That's my understanding of the record.
So you're saying that the representation, at least as far as the record discloses, the representation was confined to the probation violation and not to any other matters?
That's the way it appears to me.
Except what about the statement by Mr. Holden that Mr. Bennett asked him to seek a continuance on the motion, on the hearing on the motion to withdraw? Wouldn't that indicate that Mr. Bennett at least was going to consider it? Now, maybe he would have said, I don't think it has any merit, let's not proceed. But we don't know that. We could speculate that, but we don't have anything that would indicate that.
Perhaps. And I think that is also a problem because we don't have any indication that he would have signed on with the motion. We also don't have any indication that he would not have because he was not present at all. And that does present a problem here. But once again, I don't think that this court can speculate to what was said to Mr. Holden by Mr. Bennett outside of the record.
I agree with that. So aren't we in a position then where what we've got is somebody represented by counsel whose counsel couldn't be there for a hearing, where the court went ahead with the hearing anyway, even though the client asked for a continuance? And why isn't Mr. Whitfield right that we should remand the case for a hearing where he either has counsel or he doesn't have counsel?
So my thought is this. My thought is that the fact that the trial court did eventually hear this motion without Mr. Bennett present is really a harmless error, and at this point of no real consequence because the trial court should not have heard it anyway, without Mr. Bennett having filed the motion himself or filing something or indicating in some way that he was also inclined to agree with the motion or to agree with the relief.
Well, but I think on the harmless error prong, I mean, he seemed confused at the plea hearing or reluctant. It's the record is a little bit suggests that there may be a lack of understanding. So it seems like there could be ammunition for a lawyer who understands these things to present the case a lot better than a pro se litigant could.
And I don't disagree with that. I think there very much could have been a reason to have that motion filed. I just don't think that the record indicates that Mr. Bennett signed on with it in a way that I think this court should consider. While I would agree that I think that there does seem to be some hesitation on his part, I do also think that there's nothing in the record at this time that would indicate that Mr. Bennett had any intention to be present or to have signed on to the motion. So moving forward a little bit, I think that once again, the fact that the trial court did hear it and subsequently denied it is of no consequence at this point because the trial court could not have heard it under these circumstances. I'm going to leave my argument at that and submit on my brief, Your Honors, unless there are any questions.
All right. Any questions for Ms. Tucker?
Yeah, thank you.
Thank you.
Thank you, Ms. Tucker.
Thank
Mr.
you.
Whitfield, you have 5 minutes left and you are muted before you start. I just wanted to give you a heads up.
Thank you, Judge. So just a couple of points. And again, the reliance on state v. Smith from the state, I think is misguided here. The reason that I believe Ms. Tucker and that court said that they couldn't properly consider a pro se motion was because at the time the pro se motion was filed, those individuals, or Mr. Smith in that case, was represented by counsel. And all the progeny of cases before and after that, counsel was already on the case, had entered an appearance, things of that nature. And then you had a litigant go out and file a pro se motion. And so that's the situation where the court cannot hear that pro se motion without the indications from the attorney that they, whatever's got to go on. But again, the situation is a little bit different because a pro se motion was filed and then counsel was retained. And I heard a discussion between the court and Ms. Tucker. We don't want to speculate as to what Mr. Bennett's intentions were. So we're kind of confined to the record. But what we do know is that he put in a notice of representation prior to that hearing date. We also know that Mr. Holden indicated that Mr. Bennett was supposed to be there. It was hired for that sole purpose, and that he asked for a continuance so that he could be present at that hearing. It wasn't so he could be present at a probation violation hearing or anything else that was pending. He asked for a continuance to be present at the motion withdrawal to plea hearing.
I don't want to be misled here in my own mind. It was Mr. Holden who requested the continuance, however, wasn't it? Not Mr. Bennett?
Mr. Holden requested a continuance upon the direction of Mr. Bennett.
Okay, so we have nothing in the record that indicates that Mr. Bennett called the courtroom and asked for a continuance.
I am not aware of anything to that nature, Judge.
Thank you.
The only thing I know that Mr. Bennett did was put in a notice of representation prior to this hearing date.
On the 13th.
On the 13th. Other than that, I can't speak.
Actually, I think he may have made an appearance on the 11th. It finally got journalized on the 13th.
So we don't have to speculate about that. If he made an appearance and he put in his notice of representation, it's clear that Mr. Holden was represented on this date at the time that he went in front of a judge and was essentially forced to argue his motion to withdraw the plea. And again, when we get into that particular argument, he didn't waive counsel. Again, he was forced to proceed without counsel. And so then we can get into whether the standards were viewed properly, whether it was the Strickland standard, whether it was the voluntary plea standard, which is what the judge focused on, is whether or not his plea was voluntary. He didn't get into anything having to do with the performance of counsel. And performance of counsel, and I know that's not really, I don't think that's an issue right now, but the performance of counsel is different when you're talking about a plea versus when you're talking about a trial. So when you're talking about a plea, just by the nature of events, you don't have a lot in the record oftentimes to determine what was said, what counsel did, versus a trial when it's been recorded. And that's when you can see the deficiencies. And so again, that standard I think is a little bit down the line. But for our purposes today and what we hope to get accomplished today is to allow Mr. Holden to have his day in court with counsel that he retained and argue whether or not he should be able to withdraw a guilty plea that he believes was submitted, without proper assistance from counsel. And so that's what we hope to get from the court today.
Any other questions for Mr. Whitfield? Counsel, thank you both for your arguments this morning, and thank you for indulging our numerous questions. We will take this case under submission and give you a timely written opinion. That will conclude the arguments today for the First District Court of Appeals. Thank you, everyone.
Thank you.
Thank you.